Hello everyone, this is Tom Fox and I'd like to welcome you to episode 91 of Compliance Into the Weeds, a podcast where, with Matt Kelly, founder and editor of Radical Compliance, we take a deep dive, literally going into the weeds for a compliance or compliance-related topic each week. Today we take up a speech by Matthew Miner where he discussed the new FCPA Corporate Enforcement Policy around mergers and acquisitions. We talk about its background history, where the DOJ has come out on that previously and where it may be going forward. We also discuss opinion releases, particularly around the M&A context, but also how companies can use the release procedure to help get answers to specific questions. It's a very interesting exploration of two very relevant topics under the FCPA. Compliance Into the Weeds is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, a compliance evangelist, and I'm back again for another episode of Compliance Into the Weeds with my good friend and colleague, Matt Kelly, founder and editor of Radical Compliance. This is the podcast where we take a deep dive, literally going into the weeds on a compliance or compliance-related topic each week. Today, we're going to take a look at a speech given, I believe, last week by Assistant Deputy Attorney General Matthew Miner, to the, and this is a mouthful, the American Conference Institute 9th Global Forum on Anti-Corruption Compliance in High-Risk Markets. Gosh, Matt, they really need a title editor.
They do indeed. Yeah.
So, Matt, it was an interesting speech, a couple of several different things, actually, for the compliance practitioner, but I wanted to focus on maybe a couple today. You wrote a blog post about one of those, or I guess both of them, the new change in the mergers and acquisition enforcement focus of the FCPA, and then a few words about opinion release. So you want to set the stage for us?
Yeah, sure. So as you said, this was Matthew Miner, who I believe is the Deputy Assistant Attorney General, and so he would be over the fraud section that would actually be enforcing FCPA cases and would probably be under the new Assistant Attorney General, Brian Benkowski, who was just confirmed earlier this month, I think, by the U.S. Senate. But we don't really have that many speeches from people who are not Deputy Assistant Rod Rosenstein, because there really haven't been that many other assistants or deputies in the Justice Department until very recently. So there's Miner. He gives this speech. The first half of it really isn't anything that people have not heard before. It was just a general kind of overview about FCPA enforcement and all of that. Then he gets into applying the corporate enforcement policy to M&A deals and acquisitions, and raising the issue of how the enforcement policy would apply to inherited liability for an FCPA issue at a subsidiary you have acquired or are looking to acquire. Now, the corporate enforcement policy, in case anybody hasn't heard about it yet, although we've talked about it quite a lot, is that basically the Justice Department will presume to give you a declination to prosecute if you voluntarily disclose FCPA trouble and you cooperate with regulators trying to hold individuals accountable and you remediate the underlying weakness. You do all three of those things, and then you won't get a monetary penalty. You will not get a DPA or a monitor or anything like that. The presumption will be that you get a declination, although you may get a declination with disgorgement of ill-gotten gains. And this was the first time that somebody at Justice talked about how that applies to M&A deals and subsidiaries and inherited liability. Miner was pretty clear that the department does not want to be seen as an impediment to doing M&A or to expanding overseas, to acquiring subsidiaries. That's not a surprise because the Trump administration is trying to promote itself as the most pro-business administration ever in history of the universe. And this, of course, would fit in with President Trump's general themes along those lines. And then Miner also did say that the Justice Department is aware that performing due diligence and rooting out FCPA issues during these processes and transactions, that can be hard. And he said, and this is a direct quote here, "We're fully cognizant that in some instances, an acquiring company has limited access into the target company's data or records, and perhaps even more so when the target company is in a high-risk jurisdiction." I am of mixed minds as to exactly how breaking this news is, because I had thought it was implicit in the FCPA Corporate Enforcement Policy that it would carry forward into M&A deals and other transactions like this. Maybe it's true it was implicit and nobody had just gotten around to making it explicit yet. Or maybe there is really sort of fresh news here. I'm not quite sure. And Tom, if you had views, I'd be eager to hear them. But on the other hand, I always keep coming back to, this is the Trump administration. Like, what else are they going to say? They're going to say that if you are trying your best and you can prove it, we're going to work with you, not hang you out to dry. And I think that is always going to be the MO of the administration across any type of issue, including inherited liability and M&A transactions. So I still struggle to figure out how groundbreaking this news is, but that's what the news is.
So I think we're aligned, but let me just kind of go through my analysis, because there were a couple of points that I felt had a little bit different focus. First of all, Mike Volkov, I think, has been either the most strongest or the most strident by articulating a position that if you follow the requirements under the 2012 guidance around M&A, that you'd have safe harbor. And he's been very open, upfront, and articulate in that if you follow these steps, starting with the pre-acquisition due diligence, moving forward into your post-closing role of incorporating the acquired company into your compliance program, training all individuals, then performing an FCPA forensic audit, and turning over any of the negative findings or findings of an FCPA violation to the department, that you're going to get a declination. The Assistant Deputy Attorney General, if I got that right. Did I get that right?
Deputy Assistant.
Deputy Assistant Attorney General. There we go. He focused on the word from the 2012 guidance that the department may decline. And he said that, quote, "While I know from my experience that may decline is a significant sticky point for corporate management when deciding whether and how to proceed with a potential merger or acquisition. There's a big difference between a theoretical outcome and one that is concrete and presumably available." I have always felt, agreeing with Mike Volkov, that this really was a safe harbor. And if you took those steps, you would receive a declination. So this, to me, was really a continuation of the policy in the Trump administration of continuing prior policies from the prior administration around FCPA enforcement and further clarifying those in the form of incorporating specifically into the new FCPA Corporate Enforcement Policy announced in November. Now there is the presumption of a declination. That specific language obviously comes from the 2017 change. So it's a long-winded way of saying I see this really as a continuation and clarification of a prior policy. But the thing that's maybe a little bit new by rolling it into the new FCPA Corporate Enforcement Policy is there has to be disgorgement. And previously, that was not required to receive a declination under the 2012 guidance, so that if a company fulfilled those steps within a reasonable time, generally perceived to be 180 days, 18 months, then there would be a declination. But now, if the bribery and corruption continued during that time, you're going to have to give the money back. It's an open question as to whether you'd have to rebate monies from prior to the merger. But if a company was not subject to the FCPA prior to that merger, then perhaps not. I would also add that we previously had an opinion release on this specific topic. And the specific topic was where a U.S. company was buying a Russian company. During the pre-acquisition due diligence, they discovered bribes had been paid. The target company had not been subject to the FCPA. The acquiring company agreed to remediate thoroughly, train, and incorporate the new company into their compliance program, and they got a preemptive pass through the opinion procedure release. So not a lot new, but really that change at the end, though, moving from turning over the results of a forensic analysis to now adding to a disgorgement requirement, I think that actually may be the bigger change here, Matt.
I do have one other question in my mind, Tom, and you may know this better than me, but I also am thinking clearly the Justice Department is still trying to encourage people to or companies to voluntarily disclose FCPA trouble. But if you're disclosing it about inherited liability in an overseas operation, by definition, there's another jurisdiction that's going to be out there somewhere because the overseas operation is overseas. So if you volunteer this to the U.S. regulators, could that somehow then wind up getting disclosed to the home country's regulators who might take a different view about your liability issues, and they might try to take a whack at you under their own anti-bribery statutes? And again, it's an extra dimension that you need to think through, although that is not directly tied to what we were talking about here, which is, yet again, the Justice Department saying, please cooperate and make good efforts, and we will try and work with you as best you can. That's not news. But I do wonder about this, extra wrinkle of foreign governments and what they might try and do with that intel.
So that's a great point, Matt. The question would be, in the context you use it, who is the quote you, Y-O-U, end quote? Is that the acquiring company, the U.S. company, who would accept some inherited liability, or is that the acquired entity who no longer exists? Obviously, they would have employees or employees from that time period who could potentially be subject to criminal prosecution, but that's an excellent issue, and there's certainly nothing in this speech to point one way or the other. But here's where I come down on this, Matt, and I've always thought this: if you acquire a company that's been engaging in bribery and corruption, and they continue to engage in bribery and corruption after the merger, it's no longer them who are engaging in bribery and corruption; it's now you. And if you were engaging in bribery and corruption, whether or not you knew about it, that's a violation of the FCPA. If you stopped it and reported it to the government, you're not engaging in bribery and corruption. So that the notion of inherited liability, or what we used to call springing liability, for me has just been a complete misnomer. That the liability comes from allowing the bribery and corruption to continue after the merger has closed, so that a company clearly subject to the FCPA, or at least have U.S. jurisdiction for the FCPA, is engaging in bribery and corruption. So that's the other point on this that is not really articulated in this speech, but that if you stop the DOJ wants you to stop the conduct, and this policy further incentivizes companies to do so. But I think the incentive was there all along.
Yeah, I tend to agree, and as I will always say, my default position is, if you're aware of it, disclose it. If you are aware of it and you don't disclose it, immediately all of your options shift to degrees of bad should this come out. At least if you disclose it, there are some potential options that could be interpreted as good. None of it is probably going to be a fun time, but that's nonetheless, when in doubt, there should be no doubt. I'll put it that way. If you know about it, cough it up.
So in the early to mid part of the prior decade, there were a large number of FCPA cases that arose through a merger and acquisition. But in every one of those cases, it was where the acquiring company, the U.S. company, bought a company that was engaging in bribery and corruption, and it allowed that bribery and corruption to continue for some period of time. So that's what led to the liability. The kind of seminal change in everything was in 2008, when the Department of Justice issued the 0802 opinion release, involving Halliburton, where Halliburton could not, under English law, do a full pre-acquisition due diligence on a potential acquisition's third-party agents. And so they agreed with the department that the department would allow Halliburton an expedited due diligence after closing, reporting directly to the department if they found anything that violated the FCPA. And that led to some other enforcement actions which elongated those timeframes. But Chuck Ross explained to me once that the problem is if you cannot do pre-acquisition due diligence, you're really compressed after closing. And the compression is, one, some pressure from the government, certainly, but two, you've got to get in there and see if they're doing anything illegal. And that's in your business interest to do that. So the M&A part of FCPA enforcement was a little bit different. Certainly 10 years ago, it's evolved, and this policy may not be the end of it, but it certainly enshrines something I think the Department of Justice has actually tried to get companies to take these steps to stop bribery and corruption, report it to the government, and either have a safe harbor under the 2012 guidance, or now move to the new corporate enforcement policy where there's a presumption of a declination.
Mm-hmm. No, I would agree with all of that. If we can shift gears just a little bit, the other interesting point I thought from Matt Miner's speech was, since you and I have been talking about various hypotheticals and whatnot, how these things could be viewed, Miner also gave a plug for people to use the FCPA Opinion Procedure, which I have not seen in a couple of years now. But for those who might be somewhat new to the FCPA profession, once upon a time, you could write in to the Justice Department asking them for an opinion on some circumstance, and they would give a non-binding, I believe it is, view on how they would probably interpret some set of facts that you are writing in, which, of course, I'm sure you're just writing in for a friend. If we're doing this and we're hosting these foreign government officials and flying them in with the layover in Hawaii for 3 days, is that going to look bad? Matt Miner said that he would encourage people to use the opinion procedure process. And in fact, the last opinion release that we saw, I think, was in 2014 when they published like 2 that year. But once upon a time, there were a steady stream of opinion procedures or opinion releases, not a lot, a couple every year, more than 2, but never more than 6 or 7. I wonder who's actually going to write all these opinion releases, because it's not like the Justice Department has a whole lot of staff these days. But nonetheless, Miner was saying, go ahead, use the release, the opinion process, because it's there. And I think that's a fine idea.
So let me just pick up on that, because I think you're absolutely right. But let me add, Matt, that the opinion release procedure is designed not to answer hypotheticals, but to answer real facts and real life situations that companies face. And if the Department of Justice issues a formal opinion release, the company gets a pass. And it says in the opinion that based upon the facts that they have been presented to us, we would not initiate an FCPA investigation. So the company gets a very strong pass. I mean, a very strong opinion that the DOJ will not initiate any enforcement action. And more to the point, that we had several opinion releases from about 2011 to 2014, where frankly, if you had presented the fact patterns to me 100 times, I would have said 100 times they were FCPA violations. And the lawyers involved in the opinion releases for the companies in question did an excellent job of presenting facts, presenting legal arguments to the Department of Justice that the Department of Justice accepted and said they would not move forward. So we had such things as a foreign government official would have their child's health care paid for by a vendor of that particular government agency. We had one company who hired a royal family member from a country that still had a royal family to lobby that country's embassy in the United States. We had several around gifts, travel, and entertainment. We had the aforementioned M&A policy that I alluded to in our previous discussion. So the opinion procedure release, I thought worked. I thought it worked well. The Halliburton one, for instance, back in 2008, that was because Halliburton was exasperated that they could not get past the potential FCPA liability from the target company. So they presented a fact pattern to the Department of Justice, which the DOJ accepted, that they would not prosecute if Halliburton move forward in an extremely compressed time frame post-closing. It's a long-winded way of saying that the opinion release procedure works. It can work. We've had opinion procedures released in less than 30 days from when they were first submitted to the government. So this is not a 12-month, 18-month, 24-month process. It can be a very powerful tool. But even as recently as this year, I was discussing this with a potential client, and they were reluctant to, open the kimono to the government. They did not want to put the facts out to the government because they are feared that that would lead to an enforcement action. And I'm sure there's a way that whether it can be, the old pirate parlay or some sort of flag of truce or some way to get information to the department which would not indicate or not confess liability. So I really applauded Minor for bringing this up because it's a tool that is unfortunately now not used at all. And I think it can be powerful. And then certainly for companies, it gives you a very good idea of not only the DOJ's thinking, but a roadmap to doing things that, as I said earlier, might appear at first blush to be FCPA violations, but apparently are not.
Well, I agree with that, although here is my question. I would say, personally, I am all for an FCPA opinion because once one is published, people like you and me get to pore over every letter and line and sentence and interpret it. I'm all for that. However, I seem to recall earlier this year when the Associate Attorney General Rachel Brand, just before she pieced out and took the top legal job at Walmart, on her way out the door, she did publish something that said, we would not be looking at sub-regulatory guidance anymore. And my question is, how much do these opinion releases fall into the realm of sub-regulatory guidance, especially if you are a company that is very similar in circumstance and facts to some opinion release? You did not, that you didn't submit it, some other company did, but the fact pattern is very similar to your situation. Can you rely on that or not, or how much can you rely on it? Because there are many other voices in the Justice Department and elsewhere in the administration that say we have to knock off all this sub-regulatory guidance, which I would very much say that this fits the form of sub-regulatory guidance. So, I'd be curious, how would we clarify the distinction between the two? And I don't know if you have any thoughts, but that was one thought that did run through my mind.
So actually, I do have a thought on that. This is not sub-regulatory guidance. This is actually a requirement of the FCPA itself. So this is written into the FCPA, the opinion release procedure. So it is responding to a statute. So for the company that submits, I think clearly, because it's statutory in nature, a statutory response, that it's going to be a good opinion. And then as to a company that might rely on it going forward, if they had a lawyer who interpreted the opinion release and put it to the company's facts, and they used that as a good faith basis for making a decision going forward, I would find it hard to believe the Department of Justice would completely discount that in any type of negotiations. And if they did, they would probably forever kill off the opinion release procedure, because it would come out in the statement of facts that a company had presented that, and that argument was rejected by the government. So it really wouldn't be in the DOJ's interest to at least not listen to as a good faith belief that there was no FCPA violation. A company looked at an opinion release and then used that as a basis for making a decision going forward. So I guess that's where I shake out on that question.
I mean, in a practical sense, I agree with you. I only raised it because, frankly, I think the people who talk about sub-regulatory guidance are more anti-regulatory zealots who are lost and in love with the theory, but have lost touch with reality. That in reality, I would agree with just about everything you say, but I could see that question occasionally being raised, especially by anybody who has very similar facts, but is not the one who actually got the opinion release. But thank you for clarifying that.
So, Matt, really, there was turns out there was quite a lot to unpack here with Matthew Miner's talk. I guess once again, I always find it appropriate when really any Department of Justice official gives us information, because I think it provides some insight into not only how the DOJ is thinking through things, but also what they would like to see from corporate respondents moving forward.
Mm-hmm. I would agree.
Well, this has been a fascinating exploration of speech by Matthew Miner and Matt Kelly's blog post, FCPA Enforcement and Inherited Liability. Matt, I look forward to continuing the conversation.
Thank you, Tom.
Hello, everyone. This is Tom Fox. I'd like to thank you for listening to this episode of Compliance Into the Weeds. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Matt at mkelly@radicalcompliance.com. If you've never done so, I would appreciate it if you would leave a review of this podcast if you've listened to us on iTunes, as it would help in our rankings. Hope you'll join us again next week for another episode of Compliance Into the Weeds. Compliance Into the Weeds is a part of the Compliance Podcast Network.